Our second case this morning is Mary and Amy Gunn versus Mary Dixon and Debbie Miller. Case numbers 127024, 025 from Cowley County. If council could please come forward and announce your appearances.
Jerry Bogle, on behalf of Mary Gumm and Amy Gumm, appellants.
May it please the court, Eric Westlander on behalf of defendants appellees Mary Dixon and Debbie Miller.
You may begin, counsel, whenever you're ready.
I would ask to reserve 4 minutes.
4 minutes is granted.
Your Honors, this case began when Mary and Amy began in the breeding of border collies in 2011. When they did, they created a website. That website was Nightshade's Border Collies, and over the years that brand became very recognized as a high quality puppies. That was 2011. And in 2015, the defendant, Dixon, bought a puppy from Mary. She didn't buy a puppy from Nightshade. She bought a puppy from Mary. And why do I make the distinction? Because that dog that she bought that day, she was enamored with the colors on it, and she was told this is not a Nightshade dog breed. I have this dog here on behalf of a man named Haynes, and I'm selling it for him. So number one, she was told in 2015 when she bought the dog that it wasn't a Nightshade dog.
Did that information ever change?
Number two, when she registered the dog that she named Toby with the AKC, American Kennel Club, she got a certificate back saying breeder, Mr. Haynes. Number two. Number three, did that ever change? Number three, in 2018, January 3rd, she created she sent a message to the website of Nightshade saying that that she knew that she didn't have a Nightshade dog. That was January 2018, and then later in 2018, she filed a claim with the Better Business Bureau, saying, and she filed on the basis that she thought she was getting a Nightshade dog, and she didn't. So clearly, she wanted one. Clearly, she knew she didn't get one. Number three, in September 2018, now we're still in the same year, but the months have moved along, she hacked into the Gumm's website, and the way she did it was that she was astute enough that if she put in real Nightshade, no matter whether you put in real or you just put in Nightshade, it would pull up the real Nightshade account, which was Dixon's website, and she began to make negative comments about the dogs in 2018 September, and that negative comments included the fact that the Nightshade line had epilepsy.
Counsel, I think we understand a lot of those facts from your brief and from opposing counsel's brief, but I want to ask you just some basic questions.
Please.
Do you agree, or are you, it seems like from your briefs on appeal, you're only arguing the count for libel?
Yes, ma'am.
The others are not at issue, and do you agree that as to that question, on appeal, our standard is de novo? We can look at all of these factors?
I do agree.
Okay, that's helpful. If we talk about just when we get into libel, the actual malice question, What evidence is there of record about defendant's actual malice?
The malice, and I have some entries here that I'll make reference to, and I'm going to work. Number one, Dixon continued to make negative claims, multiple negative claims claiming epilepsy between 2018 and 2022. The statute of limitations on this case begins in January 26, 2022. So I brought in those pre-statute of limitations cases to show the negative attitude she had, the malice that she had, the fact that she indicates she wants to close this breeder down. So number one, it's like saying your neighbor has leprosy. Your dog line has epilepsy. You're beginning to move toward killing the business if any of that is believed. And she talks about it in 18, 19, 20, 21, and finally within the statute of limitations, it gets worse in 2022. And
so, as far as tying this into the actual falsity of the statement, her dog had epilepsy. That's not the issue, correct?
That is not correct. She did bring in a piece of paper from a veterinarian that said that the dog died of idiopathic epilepsy, and the veterinarian was taking the words seizure, epilepsy, throwing them together. Number one, idiopathic, I don't know where it came from, but the dog has seizures and the dog died. But do we deny that my client ever had, in the period from 2011 to 2020, ever had a designation of epilepsy by any of the dogs that they sold? Sure, they do. And I recited that in the brief.
And so, but the claim of falsity in the malice isn't that her dog had epilepsy, it's more that it was in the line that the nightshades were breeding, correct?
That's right, and I'm going to skip to another part of my brief. I've put it in the brief, but I'll emphasize it again, and that is that their facility, their dogs were examined by a veterinarian, a licensed veterinarian, every year from the time she started the business, because that's a Kansas statute, and she met the Kansas statute, and she proved it up with the Kansas Department of Agriculture. So number one, never any indication that there was a problem with seizure or epilepsy in the line. Number two, she was examined or inspected by the AKC, American Kennel Club, in 15, 17, 18, 19, 20, 21, and 22. Passed every time. The AKC has a big interest in keeping their dogs healthy because they have a brand that they are protecting, which is like we're trying to protect Nightshade in this case. Number three, the Kansas Department of Agriculture inspected her in 14, 16, 17, 18, 19, 20, and 21, and never had a problem. Passed every time. In 22, they had some issues, and including the fact that on a freezing winter day, they appeared in the morning and the water was frozen in the water pans. Amy was out replacing the water. Nevertheless, they said didn't have potable water. So nothing ever in all the years of all the inspections indicated that they had any kind of illness with their breed in relationship to seizures or epilepsy. The Kansas Department of Agriculture, when they inspect the facility, they have 26 separate categories they look at to see pass, fail, pass, fail, pass, fail. Very intensive in terms of that subject. So do we think that we have proven through that? How do you prove a negative? And that this is our ability to prove a negative. We were inspected over and over and over and never had what is being alleged by the defendants in these cases that was going to cause their business to fail.
So if I could dogleg just a little bit to the damages part. So damages in cases of this nature are not presumed, they have to be shown. So where can I go in the record to find evidence of actual damages suffered here?
Well, we put in our brief a statement of 6 different emails, not emails, 6 different digital reports on the website saying we were going to buy a dog. We read about you on your online, and now we can't do it. We created 6 exhibits. On the petition, they were double K through double P, but I changed that to record citations. So I do have record citations to those 6 digital messages saying I was going to buy a dog, but I can't because.
So normally for libel, what damages are looking to damage to your reputation in your community? So you're relying upon those to say that the buyers would prove damage to their reputation in the community, people who decided not to buy the dogs.
Right. Well, when they went to the website for Nightshade, it kicked up Real Nightshade, which was the Dixon hacking, and it said negative things over a period of 6 years. I mean, 18, 19, and I, albeit the statute of limitations limits it to 22 and thereafter. Of course, that we believe that is negative as to the reputation of the business and the reputation of the parties. And I do have in my brief some recitations, what I'm calling third-party posts, and there were posts in there. One of them said, referring to the Gums, we hope you rot in hell, and some other more vulgar comments that I won't repeat. Number 2, another one says, I don't know how you sleep at night. A third one says, what you're doing makes me sick. So clearly their reputation was being attacked, both personally and business-wise, and they lost money because of it, and they lost personal reputation because of it.
Mr. Vogel, your time has lapsed. If you want to, you still have your 4 minutes rebuttal, but if you want to.
I would only emphasize the knee Comanche versus, versus Stumpf, which is a case that gets around to identifying the burden of proof upon the plaintiffs in this case.
Do you have a cite for that by chance?
Do I have a citation? I do not have the citation. It came out in October 2022, came out of Sedgwick County, and it is a great case in relationship. Let me use another minute of my time. I do have a citation now. It is 123,642, Kansas App, October 7, 2022. So it was an unpublished opinion, Knee versus Stumpf, and it came out of Sedgwick County. The district court said you don't even come within the definition of the anti-SLAPP statute, but when the appellate court got it, they said we're not going to talk about the first step. We're going to talk about whether the plaintiff had a prima facie case, and they say the resolution of the second step, that's by plaintiff, by its very nature does not require the resolution of witness credibility or of conflicts in the evidence, since it depends on substantial evidence supporting a prima facie case. As such, the second step is a question of law. Separate paragraph. A prima facie case, we look at whether the evidence, if unrebutted, would be sufficient to support a verdict or judgment of that party. And finally, another separate paragraph. We are to consider only substantial evidence supporting a prima facie case. That is a slight burden to satisfy. That's a separate sentence. And he has done so precisely because we cannot and do not consider factual conflicts presented in the evidentiary record. Thank you.
You'll have 2 minutes remaining for rebuttal.
I'm sorry?
2 minutes remaining for rebuttal.
Thank you.
May it please the court. My clients, Debbie Miller and Mary Dixon, are dog advocates who have spoken out in opposition to the business and breeding practices of the plaintiffs based on their beliefs, informed opinions, and experiences, particularly in the case of Mary Dixon. And a suit like this, with the potential to chill the defendant's exercise of free speech, freedom of association, or freedom to petition the government, is just the kind of case that our legislature intended to fall within the special protections of the Kansas Public Speech Protection Act, KSA 60-5320.
And there's really no dispute about that this case falls within the protections.
At this stage, Your Honor, that is correct. I think there was an early attempt in some of the early briefing by the plaintiffs to establish that it did not, but I think pretty clearly it does, and that has not been seriously disputed in the recent stages or on appeal. So I won't spend time on that unless the court wants me to. Yeah. So the trial court properly applied the Public Speech Protection Act, which is important in this setting to discuss because it does shift the burden to the plaintiff to establish each and every element of a claim by substantial competent evidence. So I'll walk through the elements of a defamation claim, and what was particularly proper for the court to conclude here was that the plaintiff failed to show a demonstrable likelihood of prevailing as to their count for, as to at least three elements: factual falsity, actual malice, and damages. So the elements of a defamation claim, typically the formulation in Kansas law is a publication that is factually false, defamatory in nature, meaning it causes, by its nature, by virtue of its falsity, would cause the reader to potentially think less of the plaintiff. So it has to be that type of a statement to begin with. And the court has kind of a special role in defamation cases. It can look at the statements. It must examine them in context. It can construe, for example, whether the statements are even capable of a factually false or factual meaning in the first place, or whether they're statements of opinion, hyperbole, rhetorical flourish, things of that nature. It can construe and should construe how a reader of ordinary intelligence and attention would interpret those statements. And it can also construe whether the statements are substantially true. That is, close enough to the center of the bullseye, maybe not at the exact center of the bullseye, but close enough such that the effect on the mind of the reader is no different than the literal truth that the plaintiff is advancing. So all of those things are things that the court must evaluate when reviewing these statements in context.
Did the district court here indicate which of those it is focusing on, is substantially true? Or
the court held that as to factual falsity, this threshold element, if you will, all of the statements were either matters of opinion. The term puppy mill wasn't discussed in counsel's argument, but that was a lot of what was complained of by the plaintiffs, the use of the term puppy mill. That term is an inherently non-actionable expression of opinion. It's a figure of speech. A dog breeding operation is not a literal mill with machinery that turns around. It's a figure of speech. There's a case directly on point from Missouri, highlighted in our briefing, the Smith case, that concludes as much. And so to answer your question, Your Honor, the court did start by finding that with regard to all of these statements, and I'm happy to discuss individual statements if the court is inclined to get into the weeds on those, but with regard to whether they can first be shown as factually false, that is the plaintiff's burden because of the Public Speech Protection Act. The trial court properly concluded that these were all either statements of opinion, their opinion of the Gumms, and their practices, their dislike for the Gumms in one case, protected opinion, the use of the term puppy mill, and certain other opinion statements, what they think is important for advocates to do if they have had issues with dogs. Beyond that substantial truth, the court held that the plaintiffs had failed to set forth substantial competent evidence of falsity. That is, that these statements were not substantially true compared with the version of events that the plaintiffs were setting forward. And so, for example, for the plaintiffs to assert, as you've heard, an argument that Toby, Mary Dixon's dog, did not have epilepsy, or the use of the term epilepsy required a showing of genetic epilepsy or hereditary epilepsy. In the plaintiff's view, it was not enough for Mary Dixon to have had a evaluation by her veterinarian saying Toby has epilepsy. She had to put him to sleep. That's her truth. That is supported by her declaration. And the only way in which the plaintiffs attempted to show the substantial falsity of that statement is to quibble with the definition of the term epilepsy. So in that instance, it fails for factual falsity or lack of substantial truth. Similarly, there's been discussion of whether Toby was in fact a nightshades dog. Mary Dixon, when she complained to the Better Business Bureau that Toby was having seizures, I inquired about his origins, his litter mates, and I was told by the Gums we had this dog on consignment. We had the mom and dad for a friend or an acquaintance. That was new information to her. She filed a complaint with the Better Business Bureau, and the response by the Gums, which was not addressed at all in the briefing on appeal or in oral argument, was Toby is a nightshades dog. Toby is a nightshades dog. He comes from some of Nightshade's lines. And so for the plaintiffs to now suggest it's false for Mary Dixon to assert that Toby was a nightshades dog contradicts what they told the Better Business Bureau. But I don't think the court needs to ultimately find any of these statements to have been substantially true, to uphold the trial court's ruling on that ground, simply because the next step is, even if you assume a factually false statement, something that can be proven demonstrably false, not a matter of opinion, not a matter of hyperbole or rhetorical flourish, the plaintiff faces, in this case, because of the nature of the speech at issue on matters of public concern, there is a qualified privilege that applies under Kansas law, not only to statements of about issues of public concern, which these are as defined in the Public Speech Protection Act, but also statements about public figures. Limited purpose public figures must prove actual malice.
And they seem to agree with that by arguing that they met the standard of actual malice here. So could you address that?
I would agree, Your Honor. There has not been a serious dispute that the actual malice standard applies. What is the evidence of knowing falsity? And actual malice requires a showing either that the speaker knew their statement was false at the time they published it, or they had serious doubts, entertained serious doubts as to the truthfulness, reckless disregard. As far as I can discern, the best argument that plaintiffs have about that is the argument about Mary Dixon not, quote unquote, not really having a nightshades dog or not really having epilepsy. As we've discussed, the plaintiffs had a different version of events when they responded to the Better Business Bureau. That alone not only establishes the substantial truth of what Mary Dixon has said about her own experience with her deceased dog, Toby, but also the lack of actual malice. The plaintiffs were the ones who responded to the Better Business Bureau. Toby is a nightshades dog. And so and as set forth in Mary Dixon's declaration in support of our motion to strike, which is in the record, she always felt that she had a nightshades dog. She disputes whether she was told at the time of purchase. This came from another gentleman whose dogs we had on consignment. But setting that aside, the fact that plaintiffs told the Better Business Bureau that Toby was a nightshades dog shows that there can be no actual malice and that it is also a substantially true statement. There has been nothing beyond those kind of quibbling with Toby's origins, whether he was or was not a nightshades dog as they now want to define it, or whether epilepsy needs to be shown by a veterinarian with hereditary information attached to that. Those standing alone are not enough to establish factual falsity. They're also not enough to establish actual malice, which must be proved by clear and convincing evidence of an extrinsic nature. The case law is clear on that. It's not enough to simply make a conclusory statement that a speaker knew a statement to be false. There must be some extrinsic evidence of actual malice. With regard to Debbie Miller, who we haven't talked about, it's less clear to me, frankly, what statements are complained of that are alleged to have been made with actual malice. Debbie Miller is a nonprofit volunteer Kansas director of the Companion Animal Protection Society, an advocacy group. She has collected complaints from numerous individuals. Those are in the record. They're referenced in our brief. There's been no suggestion that those were false statements by those individuals who reported directly to Debbie Miller. There is a quibbling with findings of the Kansas Department of Agriculture by the plaintiffs, less so of U.S. Department of Agriculture findings, but ultimately, with regard to actual malice, that's not the issue. The issue is whether Debbie Miller, in fact, entertained serious doubts as to the truthfulness of her statements, or acted with a reckless disregard as to whether they are true or false. There's simply no evidence that the plaintiffs can point to that Debbie Miller acted with that mindset, again, which must be shown by clear and convincing evidence. I think the closest, I'm sorry, Your Honor.
Well, I'm just thinking of this, maybe not libel, but it's in the context of the PSPA case, and we're just looking for a prima facie case.
Correct.
How
Correct.
are we getting into these issues of what somebody's intent was? How's that possible?
Because it is their burden to at least show a minimal merit to their complaint, to show that they have even a potential to succeed and to prevail on their claim. And ultimately, they will have to or would have to point to evidence of actual malice. There is an opportunity for discovery built into the Public Speech Protection Act. The plaintiffs did not avail themselves of that. The case law is also clear, Your Honor, that in the event of a tie, if you will, quote unquote, if the evidence is just as indicative of the lack of actual malice as to the presence of actual malice, then the plaintiff has failed to meet their burden. The tie goes to the speaker, not the censor under Supreme Court case law. With regard to the element of damages, the failing there by the plaintiffs is not to show that these are quote unquote negative statements about them, but that there is nothing connecting. There's a break in the chain of causation, nothing connecting any of the particular statements of which the plaintiffs complain. Remember, each statement needs to be addressed in itself. There's no such thing as a general claim for defamation. The court looks to the exact words used, the context in which they were used. And if you can meet all of the other elements, factual falsity, publication, actual malice, even after all of that, you still need to be able to show, under Marcus v. Swanson, an actual damage to your reputation as a result of that otherwise actionable statement. And here, they have included statements from customers, potential customers. None of those are linked to any of the particular statements at issue that were non-time barred, that were before the trial court on our motion to strike.
Not expressly, but can't we look at the circumstantial nature of their business before, and here are these negative statements, and then there's 6 people who said, I'm not buying from them. Are we allowed to look at the circumstantial nature of those, view those statements collectively instead of parsing them individually?
I would suggest not, Your Honor, simply because the nature of a defamation claim requires an analysis of a specific statement to determine whether that statement meets all of the required elements of a defamation claim. And if
How would we do that then in a case of this nature where you have just individuals who are saying, I was going to purchase a dog and now I'm not? How do you link that to a particular statement?
it would be a different discussion, Your Honor. I mean, keeping in mind that it's the plaintiff's burden. They're the ones who are going to have to prove this at the end of the day. Had there been more detailed factual statements from any of these named individuals who posted online or who contacted the Gumms, that would be a different discussion.
But it seems like what we're requiring them to do is to prove their libel case as if they had gone to trial, when we're at the very opposite end of it. We're not even just at the pleading stage. We're past the pleading stage, but since it's a PSPA case, they only have to make a prima facie showing of some damage, correct? I mean, it has to be the correct type of damages, but they certainly don't. It sounds like you're talking about a trial burden of proof on damages for libel. As to being an element of the claim, I think the burden still is with the plaintiff at this stage to establish a prima facie case as to each challenge statement. And so for the same reason, Your Honor, that the plaintiffs could not prevail by referencing general, unspecified, non-specified complaints or quote-unquote negative statements about them,
that would fail absent a particular statement that met all of the elements of a claim for damages. And I think the plaintiffs have failed to do that. They've also abandoned the issue by failing to brief it on appeal, is our position.
Your time has lapsed, but I do have one quick question for you on the attorney's fees issue. Given the remarkable similarity between these two cases, was 2 separate motions to strike really necessary?
It was, Your Honor, and the reason is, again, each statement needs to be analyzed in and of itself. The issues with regard to Debbie Miller and Mary Dixon, they do overlap in that they both involve the same core concepts, but each statement is its own statement and must be analyzed separately. There was also difference in timing as to when they were served. Frankly, as it shook out, we prepared the motion to strike first for Debbie Miller. Mary Dixon came into the case later. We prepared it later for her. Whether we could have combined those in retrospect, I frankly haven't thought about, Your Honor, but there is I think the basis for addressing them separately is you have a separate really set of claims based on what statements are alleged to be at issue.
Thank you.
Thank you.
Mr. Bogle, you have 2 minutes rebuttal.
Thank you, Judge. 2 points were made that I should have made better. Justice Gardner said you're treating this burden as if it's a matter for trial, and exactly, and then the counselor argues it as if this were for trial, and all of the cases cited here, there are only a handful that actually talk about 6320, and none of them help until you get to the knee case. That's the case that says when the plaintiff has to prove a prima facie case, that is a slight burden to satisfy. We cannot and do not consider factual conflicts presented in the evidentiary record. Counsel wants to say, I had to attack each and every. The court doesn't pay any attention to the conflict. If we represented a prima facie case, then we get to move forward and try this case on its merits, not on the briefing that's been done so far. And it has been burdensome to the extent that we have done it. Nevertheless, I think it was to a large degree unnecessary because of the issue that Judge Gardner made. And see what else I thought was interesting. Again, all the case law, those are as if the case had gone to trial on the merits. And then you look at the specific elements to see whether they were, quote, proven. We don't have to prove them today. All we have to do is allege a prima facie case. And I suggest to you that way beyond allegations, in this case, we had exhibits of the alphabet through A, and then double A through double P. And every time there's an allegation in my petition, every time there's a statement of facts that I have presented to your honors, there is an exhibit for it.
You're not saying allegations or not. You're saying you had substantial competent evidence to support your allegations.
Well, allegations would be enough under the knee case. You have to take it as true, and you don't disregard a conflict of testimony. We're not at the level of proving the case at trial on the merits. But I'm suggesting to you that we went way beyond that by creating this long string of exhibits, including all the inspections. I'm not alleging inspections. I'm showing you the inspection documents for all the different agencies that I have recited to you. So we believe that, albeit much of what the counsel recited is true as to a trial on this case, but not as to analyzing the motion to strike pursuant to 6320. Thank you.
Thank you, Mr. Vogel. Thank you, Mr. Westlander. We will take the matter under advisement and issue an opinion as quickly as possible.